And now the other side. Clarke Forsythe is acting president and senior counsel for the anti-abortion rights group Americans United for Life. I was just asking Cecile Richards from Planned Parenthood about the undue burden argument. That's the argument in which they are challenging whether this law, this Texas law, should be upheld. Or overruled. What do you think about that argument that there's an undue burden being placed on women?
There's no undue burden. These are very important medical regulations, very important health and safety regulations. There have to be ambulatory surgical treatment standards, and you would want every clinic to meet those standards. Every part of those standards has a medical logic and a grounding in medical practice. Dr. Donna Campbell was a state senator who testified in support of these regulations in the Texas Senate, 23 years an emergency room physician, and she testified to the medical logic behind every part of the ambulatory surgical standards, ASC standards. There's also an absolute medical logic behind admitting privileges. It involves continuity of care between the performing surgeon and the receiving surgeon in any hospital if there are complications. You wouldn't want to go to a clinic that didn't meet ASC standards. You wouldn't want to go to a clinic in which the doctor didn't have admitting privileges. I wouldn't want my wife or one of my 5 daughters to go to any clinic that didn't meet these standards.
Is the argument before the court about medical logic or medical standards, or is it about access for rights that women under the Constitution or under the laws that currently exist already have?
There's no right to an unsafe abortion. Access doesn't mean anything if it's not safe. And you have safety for patients by meeting medical standards. These are pervasive. ASC standards are pervasive across the country. The real question in this case is, why are these generally applicable, long-standing standards not applicable to abortion clinics? And the Supreme Court, for 43 years since Roe versus Wade, has never allowed states to pass health and safety regulations in the first trimester when 90% are done. This is a landmark case because the court has not permitted that. The court is the National Abortion Control Board. They control standards in every clinic, in every state, from coast to coast, and they have never allowed health and safety regulations in the first trimester. This is a landmark case.
How different is are the options now for you with a 4-4 court, with Justice Scalia's absence? Does it change what you expect the outcome to be?
Well, based on what I heard in the courtroom today, I think the most likely result is a 4-4 split. This has happened before in an abortion case during the Bork vacancy before Justice Kennedy was confirmed in 1988. And a 4-4 split means the lower court's decision is what the lawyers call affirmed by an equally divided court. It means the lower court's decision stands.
Which would be a victory for you.
A victory for Texas, a victory for patient care in Texas, but it would not have applicability to any other state. And so most likely the court would have to revisit this issue in 2017 or 2018.
Justice Kennedy was apparently musing aloud today in the court about the possibility of just sending this back to the lower court again.
That's a possibility, but if Justice Kennedy scrupulously applies his 2007 opinion in Gonzalez versus Carhart for 5 justices, he will uphold these standards, because you don't get 2 bites of the apple to make claims and then repeatedly make claims. The clinics had all the time in the world to make their claims, and all the time in the world to put their facts in about the burden of these things, and they failed to.
The 2007, I just want to clear it up, the 2007 decision you just referred to as the partial birth abortion ban.
Yes.
How different is the situation now in 2016 than it was in 2007 when the court acted on that?
Well, if the court scrupulously applies the standards in 2007, they should uphold these regulations. But this is a unique case because it's the first time the court has had a solid record of facts in protecting maternal health. And the court has never had that before. I hope it's eye-opening for the court to see the need for health and safety regulations, the short-term and long-term risks, and the fact that access doesn't mean anything if you've got substandard conditions and substandard providers. And that's why these standards are so important.
Clarke Forsythe, acting president of Americans United for Life. Thank you very much.
Thanks, Gwen.